In our second lecture related to auditor liability, we're going to focus on liability under statutory law. In our last discussion, we made the distinction between common law and statutory law. Common law is case law that's been developed over time by judges. Statutory law is written law enacted by legislative branches of government. The primary federal statutes affecting auditor liability that you need to understand in relationship to the CPA exam includes the Securities Act of 1933, the Securities Act of 1934, and Sarbanes-Oxley. Each of these acts have been enacted to assure that investors in public companies have access to full and adequate disclosure of relevant information. Let's begin our discussion related to the Securities Act of 1933. This is generally used to regulate the disclosure of information in a registration statement for a new public offering of securities. Section 11 of the Securities Act of 33 imposes a liability on issuers and others. This includes auditors, and this is for losses suffered by, notice this, third parties when false or misleading information is included in a registration statement. Under the Securities Act of 1933, an auditor may be held liable to purchasers of securities for negligence, gross negligence, or fraud. Purchasers need only prove that they incurred a loss and that the financial statements were materially misleading. In their defense, the auditors must prove that they used due professional care, that statements were not materially misstated, and that the purchaser did not incur a loss caused by the misleading financial statement. The Securities Act of 1934 regulates companies that are required to file periodic reports with the SEC. Some of these reports include the 10K report, 10Q, as well as 8K reports. The Securities Act of 1934 makes it unlawful to make any untrue statement of a material fact or to omit a stated material fact necessary for the understanding of the financial statements. It prohibits material misrepresentations or omissions and fraudulent conduct, and provides a general anti-fraud remedy for purchasers and sellers of securities. Auditors may be held liable for fraud when a plaintiff alleges being misled by misstatements in the financial statement. As we had discussed, the Securities Act of 1934 concerns primarily with the ongoing reporting by companies whose securities are listed and traded on a stock exchange. Section 18 imposes liability on any person making a material, false, or misleading statement. Section 10b and Rule 10b-5 are the greatest source of liability for auditors under this Act. Now, it's very important that you understand the distinction between what a third party must prove under the Act of 34 versus 33. Under the 34 Act, the third party must prove that a material, factual misrepresentation or omission is present, that they relied on the financial statements, that damages suffered as a result of the reliance, and finally, scienter, or gross neglect or recklessness may be enough. In our last discussion, we related scienter to fraud. Under the Securities Act of 34, the elements for a successful case is, again, material representation, fraudulent conduct, scienter, reliance on this fraudulent conduct, a measurable monetary damage, and there must be a causal connection between the misrepresentation or omission and the economic loss. From the auditor's perspective, showing that we comply with generally accepted accounting principles is generally a defense that is appropriate for the auditor. Now, let's go beyond this and talk specifically about the Sarbanes-Oxley Act. Auditors found unqualified, unethical, or in willful violation of any provision of the Securities law can be sanctioned by the SEC. Temporary or permanently revoking the firm's registration with the PCAOB. There may be civil damages. They may require special continuing education and possibly suspending individuals from serving as officers or directors of securities, issuers, or participating in the securities industry. This is a very interesting table, and we'll spend just a few minutes talking about this. This, again, goes through the Act of 33, Act of 34, and Sarbanes-Oxley. Statutory law. These are written law enacted by legislative branches of the federal and state governments. Under statutory law, an auditor can be held civilly or criminally liable. A civil claim can result in fines or sanctions. Under certain circumstances, an auditor can be held criminally liable under statutory law, although there's been only a few instances where there's been criminal actions against auditors. The Securities Act of 33, Securities Act of 34, and the Sarbanes-Oxley Act are the three primary statutory laws that you need to become familiar with. The Securities Act of 33. In order to be successful, a plaintiff must prove only two things: that a loss was suffered and that the financial statements contained a material omission or misstatement. The auditor's defense would include the adequate due diligence and possibly the fact that the statute of limitations has expired. Under the Securities Act of 1934, a plaintiff must prove a material or factual misrepresentation, a reliance by the plaintiff on the financial statements, that there were damages that resulted from a reliance on the financial statements, and then finally, this concept of scienter or fraud. The auditor's defense includes that the audit was performed with adequate due diligence, the plaintiff's loss was not caused by reliance on the financial statements, and the statute of limitations has expired. Sarbanes-Oxley, this was created, caused the creation of the PCAOB, which has authority to investigate and sanction registered public accounting firms. The PCAOB also sets auditing standards for audits of publicly traded companies. It extends the statute of limitations for actions based on claims of violation of security laws. There's a limitation of what services auditors can provide. There is increased criminal penalties for securities and financial reporting fraud. And then finally, the Sarbanes-Oxley Act of 2002 provides protection for the whistleblowers. Now keep in mind that there are additional statutory laws that you need to be aware of, but there's no question but that you need to have a strong understanding of these three statutory laws as you go through the material preparing for the CPA exam. I hope this brief video was helpful, and I thank you very much.